Hello, and welcome back to XRP Vault, where we bring you the most recent and intriguing XRP news. We're giving away 10,000 XRP to those who are watching. All you have to do is upvote, subscribe, comment XRP is king and watch the video to the end to be eligible. The winners will be picked next month and publicized on the community page of the channel. Why is the SEC making such a big effort to eliminate cryptocurrency? Why was this particular snippet picked for these uses? Can the SEC begin to regulate cryptocurrencies? In today's video, we will attempt to provide answers to these queries. A pro-XRP legal expert has commented on the sexism lawsuit against Ripple, which appears to be coming to a close. Former attorney and Evernote ex-Ripple co-founder Scott Chamberlain listed 5 potential outcomes for the lawsuit in a thread on Twitter on March 10th, including summary judgments, settlements, and additional litigation. Legal experts claim that the regulator lacks sufficient information to support claims that Ripple's CEO Brad Garlinghouse and co-founder Chris Larsen irresponsibly or willfully issued unregistered securities. They contend that Ripple's sales of XRP on foreign exchanges are outside the purview of the court's jurisdiction, and that declaring those domestic transactions consummated in the US subject to summary judgment for Ripple would set a whole new precedent. According to Chamberlain, this lawsuit may look into whether or not Ripple sold excess tokens using unregistered investment contracts in the US. The fifth scenario put forth by the co-founders of Evernote Extra is that the case will be settled if precedents are set regarding the status of XRP as a security and the jurisdiction over international sales. But in accordance with his justification, Judge Analisa Torres decided on both sides' requests to disqualify a number of expert witnesses, including one that Chamberlain and Ripple's amicus curiae submitted. According to John Deaton, this was bad for the sexual position. Letitia James, the Attorney General of New York, filed a lawsuit against KuCoin for operating illegally as a securities and commodities broker-dealer in the state. Excellent, bold reporting. Scott Chamberlain, a former attorney and co-founder of Evernote, has 5 predictions regarding the SEC's lawsuit against Ripple. The co-founder of Evernote believes that the SEC's lawsuit against Chris Larsen and Brad Garlinghouse of Ripple will fail. Attorney John Deaton, the inventor of CryptoLaw, said that the SEC accused officials at Ripple of aiding and abetting the sale of unregistered securities. The SEC must prove that officials acted irresponsibly by failing to recognize that XR was a security. According to Chamberlain, the secrecy is unsupported. Recognizing these as American transactions, according to the former attorney, would set a precedent. The third prediction is that the court will not accept the claim that XRP is a security. This is based on the extra layer to construct. As a close friend of the Chamberlain, Deaton, who represents thousands of ARC holders and asserts that the situation lacks precedent, was drawn to this lawsuit. According to the former attorney, the regulator used this to avoid looking into each ARP trade and dealing with offshore sales. According to the former lawyer's most recent prediction, an unregistered investment contract was included in Ripple's US XRP sales. Chamberlain thinks the SEC will reach an agreement as a result of his second and third predictions. According to the former attorney, the protracted legal battle is about to come to an end, at least at the district level, because the SEC believed that waves of XRP sales abroad were understated. Inquiry about its outcome is therefore high. Deaton's predictions and evaluations mostly agreed with Chamberlain's. The lawyer anticipated an out-of-court settlement up until a summary judgment decision that would postpone a trial or appeal. The architect of the crypto legislation also thinks the SEC can prevail only if Ripple sold securities between 2013 and 2017. Deaton asserts that he doesn't foresee a significant delay in the judge's decision-making process about the motions for summary judgment. According to attorney John Deaton, the United States Securities and Exchange Commission's complaint against Ripple will be resolved shortly. In response to queries regarding whether the revelation of the judge's ruling on Dalbert motions gives any hints on the timing for her summary judgment decision, the founder of CryptoLaw today revealed this information in a tweet. The originator of CryptoLaw is a friend of the case and is able to speak for thousands of additional holders. Deaton expressed his skepticism over the likelihood of significant delays. The lawyer predicted that the judge would announce her ruling as soon as tomorrow or that it might take a few weeks. Based on what has been written today, according to the judge's ruling on the DUBR motion, both parties' motions to have expert testimony excluded were partially granted and rejected. The SEC cited expert opinions to support its arguments that XRP holders purchased the token with reasonable expectations of gains entirely from Ripple's efforts. But as the article reveals, XRP holders were the largest winners as a result of Judge Torres' dismissal of those expert opinions. The greatest winners as a result were XRP holders. To evaluate Torres' decision to strike out the expert testimony that the SEC had cited to back up its assertions that XRP holders bought the coin, it is crucial to keep in mind that the defense attorney for the defendant in the case stated that it could take another 2 months to decide whether or not XRP is a security. According to Stuart Alterity, the general counsel for Ripples, there were 3 possibilities not so long ago. The court can opt to take the case to trial or find in favor of Ripple or the SEC. Deaton has stated that the conclusion he would most like to see the court reach is the clarification of the underlying claim that sales of further bonds in secondary markets represent unregistered securities offerings. Owners of XRP would be able to celebrate a major victory even if Ripple loses the case in the lower court, and the judge rejects the SEC's argument. Scott Chamberlain, a former lawyer and co-founder of Evernote's Ripple project, claims that neither the SEC nor the XRP community appear to have profited from the recent ruling. Following a recent ruling by Judge Analisa Torres, Chamberlain made a statement in which she allowed and denied portions of both sides' applications in an equal ratio. Expert testimony is necessary for Ripple and the SEC to support their claims and evidence regarding XRP. Neither the SEC nor the XRP community appear to have profited from this ruling, as the court partially accepted and partially denied both sides' motions. The absence of Patrick's duty was one of the decision's most significant implications. The SEC claimed that the primary expert witness hired this company to investigate investors' expectations for XR. Another unexpected consequence of the DOL bear difficulties was that SEC attorneys attempted to have Judge Torres bar John Deaton and the XRP community attorney from taking part in the court case, in part because Deaton had disclosed the identity of the hot expert witness. Yet rather than forbid Deaton from testifying in court on behalf of XRP holders, the judge decided that Deaton should refrain from doing so. Attorney for the additional community Jeremy Hogan shared similar opinions, stating that it was necessary to demonstrate that investors had a legitimate expectation of profiting from such efforts. The judge's decision in favor of the SEC on the third expert witness, whom Ripple had judged irrelevant and unfairly prejudiced, was crucial in showing this. Hogan thinks that the question of a fair expectation of profits is unrelated to the expert's opinions on Ripple's incentives and activities to affect the extra price. Yet he views it as weak sauce, implying that it won't work in this situation. John Deaton, an attorney, has said in its enforcement lawsuit against Ripple Labs, the U.S. Securities and Exchange Commission made a critical blunder in correctly identifying Ripple executives Chris Larson and Brad Garlinghouse. The creators of cryptocurrencies yesterday attempted to explain why Judge Analisa Torres dismissed the gender objections to expert testimony on the non-security status of XRP by other authorities in a lengthy Twitter discussion. He claimed that the question of whether Ripple authorities acted foolishly by failing to realize that X was a security was answered by this testimony. For the court to find the executives guilty of encouraging the sale of unregistered securities, the SEC will need to demonstrate this, as the attorney previously indicated. The lawyer repeatedly asserted that the SEC and other government organizations had deemed Extract to be a non-security and that, by doing so, the agency had placed an unnecessary burden on itself. Deaton hypothesizes that the regulator will use this step to either force a settlement or reduce support for Ripples in the nascent market. Nonetheless, he believed that this was a serious error and that the regulator will probably certainly lose this poll. The lawyer for the 75,000 XRP holders who are parties to the dispute has predicted that the court's verdict in the legal dispute will come quickly.